12 Presumptions of Law, Legal and Lawful, Judicial and Clerical Notice, Part 4. Point 21, Public Oath, is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore and hereby bound to serve honestly, impartially, and fairly as dictated by their oath. If any officer of the government has a conflict of interest due to a private oath, they must here and now recuse themselves from this controversy, as I hereby decree you cannot stand under the public oath and a secret superior oath. 22. Key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates, and any such titles who have sworn a solemn public oath in good faith are hereby not immune from personal claims of injury and liability for reasons covered in previous points of this document. We're going to change that because I'm not sure. Not sure if it's point 3 or 4, so we'll leave it as is. 23. By custom, a summons unrebutted stands, and therefore one who attends court is presumed to accept the position and jurisdiction of the court. Attendance to court is by invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and the position as the accused and the existence of guilt stands. I hereby rebut this presumption of guilt by appearance and to show cause by special appearance, not general appearance. Okay, now a comment here. When you look at the 1D affidavit testimony, you will see that it has a point somewhere around 7 where it specifically goes to, if I waive my rights or inadvertently lessen my status, this is tied into that, and the reason you appear by special appearance and not general appearance. 24. By customer summons or warrant for arrest, unrebutted stands, and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by the custodians. This includes the dead legal fiction non-human person that corporate government's rules and regulations are written for. Custodians may only lawfully hold custody or property and things, and not flesh and blood, soul possessing beings. I hereby openly challenge by rejection of summons and or at the court, the presumption stands that you are a thing and property and therefore lawfully able to be kept in custody by the custodians. Because I am a living homo novus, also known as the new Homo sapiens, and an eternal being. I rebut and reject the idea my person may be held as surety for the bond and or any monies owed. Furthermore, unless the government can produce a bona fide warrant supported by oath or affirmation, I demand all charges be dismissed against my person and me immediately and correct the public record so my person and me will not be falsely detained in any future interactions with agents of the government. Comment on that. This, an eternal being, when you die, you're either going to heaven or hell, whether you are reincarnated or not. We can agree we are eternal beings if you do not get rid of that section. And it's totally valid not to. 25. The presumption is that you may be listed as a resident, therefore a ward of a local government area, and possibly have listed on your passport the letter P as you are a pauper, and therefore under the guardian powers of the government and its agents as the court of guardians. I hereby openly challenge this presumption because I am both a general guardian and an executor of the trust held before the court. The court has failed to prove I am by default a pauper and or a lunatic, and therefore I may choose to disregard the rules of the clerk of guardians or the clerk of magistrates court, and all my paperwork must be accepted into the court record without fines or fees to me or my person in accordance with New York Ex Rel. Bank of Commerce versus Commissioner of Taxes for the City and County of New York, 2 Black 620, 1863. Please take mandatory notice. Federal Rules of Evidence 201D that the plaintiff has a lawful right to proceed without cost based on the following law. The Supreme Court has ruled that a natural individual is entitled to relief, is entitled to free access to its judicial tribunals and public offices in every state in the Union. 2 Black 620. See also Crandall versus Nevada, 6 Wall 35. Plaintiff should not be charged fees or costs for the lawful and constitutional right to petition this court in this matter in which he is entitled to relief, as it appears that the filing fee was originally implemented for fictions and subjects of the state and should not be applied to the plaintiff, who is a natural individual and entitled to relief. Hill versus Hinkle, 201 U.S. 43. Real quick, make sure that you are plaintiff or defendant, depending on which is the case. 26. Members of the private bar guild presume I accept the office of trustee as a public servant and government employee just by attending a court as such. Courts are always for public trustees by the rules of the guild and the Roman system, unless the presumption is openly challenged. They say you are merely visiting. I am here by special divine appearance to clear up the matter, and I am not a government employee or public trustee in this instance. Again, depending on your spiritual beliefs, you can add or get rid of divine. Thus ends part 4. Part 5 is the final part.